Hi there, I'm April Levitt, and this is my Module 8 for EDL 851 assignment, Legal Aspect of Teacher Evaluation. So we read 3 articles, and the first article I read was mostly talking about Every Student Succeeds Act, and it discussed how the federal government no longer has control over the evaluations and that the state government needs to begin to design them, and they need to include more than just the test factors. They need to include many factors for effectiveness to evaluate those teachers. It talked a lot about the bargaining between schools and unions and preserving the rights instead of creating rights. So if the school district already had the rights, then the unions and the schools, they can bargain at keeping them. However, they cannot create new ones. The second article that we read was Teacher Evaluation Heads to the Courts. So this was multiple court cases with the two organizations, the AFT and the NEA, that were regarding unjust evaluations. These evaluations were mostly based off of the test scores that the teachers felt were unjust, that they did not get the pay that they were to get, tenure was taken, or there was incorrect data within the evaluation. Those that were completed mostly ruled for the state, and however, some were still in progress. But I did find that interesting because I know that this article was a little bit outdated. It was a little old article, and so I don't know if those court cases are still in progress, but I did find it interesting that most of them did rule for the state because so many court cases right now are coming to, so many teachers are stepping up and going to court regarding different aspects of schools. I do wonder how these cases will affect the future evaluations and laws of regarding evaluations in schools. The third article that we read was Teacher Evaluation and Issue Overview. So this talked about how there were 4 factors of evaluation, and one of them was that there was a new focus in the early 90s. There was a new focus on on research of effectiveness of the teacher evaluations. And the federal government played a big part in making those evaluations the focus and boosting an effort to make the evaluations effective. However, they've turned that over to the state, and the state or district now are driving those evaluations. And how it's interesting where proficient might be proficient in one district versus you go to another district or another state and that same proficiency will maybe be ineffective in another area. So that difference could be an issue for some teachers. It also talked about how society was pressing for the ability to non-renew teachers that are deemed ineffective. And so there needs to be some kind of a tool to be able to non-renew teachers. It did argue at the end there, it argued how are these new evaluations actually working? Are they actually evaluating teachers and their efficiency properly? And it kind of talked about 2 different reasons why they may not be as effective as what they're showing that they're being. Our district evaluation process for our first and second year teachers, they're formally evaluated once per semester. Third and fourth year teachers are formally evaluated once per year, and then every 3rd year thereafter. There's a pre-observation or an orientation to the evaluation process that has to be done prior to the formal evaluation. And this is where the principal or the administrator will sit down and just talk about the process and what are the things that they might be looking for, ask you if there's anything that you want them to look for to give feedback on within your classroom. And then they will come in and do a formal observation where at least one of them must be scheduled a day in advance. For the second one, it does not have to be scheduled. The principal can just pop in at any point. And it's no less than 30 minutes that the principal or administration must be in there. The evaluation has many competencies, indicators, and descriptors, and so it can be quite overwhelming. And so this is where the principal and the teacher might discuss certain aspects that will be focused on during an evaluation or during that observation period. Feedback on that for observation must be given within 5 days. And then there is a summative evaluation meeting with the administration after all of the observations are completed, typically at the end of the year. And this is where PD plan options can be brought up. Any advice that the principal can give, if she might direct you to the instructional coach for different areas of improvement. And then if it is a serious situation where the principal sees that there is real possible problems within the classroom that might be put on a plan of assistance, that the principal will work out at that point with the teacher and the terms of that. What can teachers do if they feel the evaluation is inaccurate or unjustly non-renewed or let go? They can put up there, or they can comment at the bottom of the evaluation if they disagree with any of the ratings that they receive. We can also meet with our NEA president to kind of look over that evaluation and understand further about what exactly we can do and how to word those documents, just to get some advice. The teachers, if they have more issues, or if they are not getting any answers and things that they would like due to that evaluation, or they feel that it is purely unjust, they can follow these 4 levels that are outlined within our negotiated agreement. Level 1 is to request an informal conference with the supervisor, and it has to be within 15 days of the event. So within 15 days, perhaps, of that summative meeting or that feedback meeting, they would need to request an informal conference with that administrator. For level 2, if no resolution is made, then within 5 days of that conference, then the administrator superior will meet with a representative. It could be the NEA president, if the teacher is a member of the NEA, or a representative of that teacher. And then an answer must be received within 2 days. If still there is no agreement that is made, then within 7 days, the teacher must file a grievance with the association's committee. And then within 5 days of that, the superintendent will meet with the teacher and the representative and discuss the situation and try to come to an agreement, which must be done within 4 days. And if there's no agreement within that, then the teacher and the representative will meet with the Board of Education, and the board president has 5 days to provide a final decision. That is as far as it goes within our negotiated agreement. The legal case that I looked up and just got more information about was where a Great Neck, New York teacher sued the district and the state due to a job rating that was ineffective for her evaluation. This job rating was purely due to student test performance. A year after she received this ineffective, she got a highly effective, and it all was due to the student's test performance. So she, in this court case, she indicated she wasn't looking for money, but she was looking for a change in the fact that the teacher shouldn't be, the formula should be changed so that the teacher isn't looked at as ineffective if they have a year of test scores going fluctuating as hers did. She was a PhD. She did have a PhD. She was a highly effective teacher in regards to many people. So it seemed like she did have some backing there for her case. The results were that the test scores would be excluded from evaluation until 2019. and then at which time there would be a new model, a new way that the teachers were going to be evaluated and introduced to that district. And so it's somewhat still open, the case is. Reflection, to ensure that I follow the legal process associated with the evaluation process. The first thing is to be familiar with the negotiated agreement. I'll be honest, I always looked through it. I signed it in years past, and this wasn't a huge part for me to understand because I didn't need to understand it as much. The evaluations that I've had have always been great, and my principals have been very good with relationship building and the evaluation process and all of that. So it's something that I, as a leader, would need to know more is I would need to know that negotiated agreement. I would need to understand it and be very, very familiar with it. And so that was kind of an eye-opener for me to read through that and really try to dig deeper into understanding my negotiated agreement and what the legal aspects of it were. Also, it was eye-opening to talk with the NEA president and become more involved with her, as I hadn't really been in the past. So just getting more information from her was very enlightening. Also, obviously, have a mentor administrator to go to and be able to get any information that I can from them and any advice that I can from others that would be more experienced to begin with. And then, of course, be more knowledgeable with the KSDE website and those laws and regulations. And I am somewhat, but, being that administrator leader, I would need to be even more involved and even more knowledgeable of those laws and regulations. And that concludes my presentation. And thank you so much. I look forward to learning more as I go throughout this course.